Death and taxes we all hear about are two things that are unavoidable, and death is certainly something that is, but taxes that come when you pass away and the fees of probate are something that are avoidable in certain states. So in this video, I'm going to give you 7 tips on how you can improve the settlement of your estate so that you avoid probate and many of the fees that often come with it. Welcome back. This is episode 224. They say in life there are two certainties, death and taxes. And though I haven't figured out a way that we can all beat death, the taxes that sometimes come with your death are something that can be avoided in certain states. That process of settling your estate is often referred to as the probate process. And in some states, probate is avoidable, and there are some things you can do to avoid that and make it much easier for your family to settle your affairs once you're gone. So in this podcast episode, I'm going to cover 7 tips on how you can do that. Now, if you're a new listener to the podcast, my goal with this podcast each week is to help deliver tips and suggestions and keep you on the cutting edge of planning for your retirement. So if you haven't done so, head over to retirewithryan.com. And if you scroll to the bottom of any page, you can sign up for my weekly newsletter where I'll deliver you the latest podcast episode, but also additional articles and tips that I find helpful for you to plan the ultimate retirement. So again, head over to retirewithryan.com and sign up for my weekly newsletter. Now, I've recently gone through the probate process. Unfortunately, my grandfather passed away. It's just about been 1 year since he passed away in October of last year. And my father has been his executor, so I've been working with my father to help him settle my grandfather's estate. And so I'm very familiar with this process. I want to share with you some of the things that I've learned from going through the probate process in Connecticut so that you can potentially avoid going through the probate process as well or make that process a lot smoother. If you know my grandfather grew up in an era where many people coming out of the Great Depression were extremely frugal. My grandfather didn't want to pay for anything if he didn't have to. And one story about that was when he purchased the last property that he owned, he purchased a condo. And when you purchase a real estate property, usually something that you get is title insurance when you're purchasing that property. The reason being to protect the property against proper title in case you don't actually own it. Well, he really didn't want to purchase the title insurance because he felt that if he was purchasing this property and he was paying cash for it, why should he have to pay for title insurance? So we went back and forth, and I finally convinced him that it was really something that he should do for his best interest. But this was an example of just how frugal he was. And I tell you this story because I had tried to make sure for all my clients that their estate was properly set up. And with my grandfather, there were definitely some things that we were trying to get him to do towards the end of his life that really could have simplified the probate process for his children and for my father as his executor. But unfortunately, he just didn't get those things done. So I want to share with you in this episode some of those tips that can make the probate process a lot simpler. Now, I mentioned he passed away about a year ago, and we're finally just my father's finally just getting this estate settled. And there's been a lot of time involved in settling this estate, and there's been a tremendous amount of cost as well, probate fees and such that have been paid that you can possibly do some things to help avoid those fees. So tip number 1 is just gift things away while you're alive. This is pretty simple. If you reduce the size of your estate, there's less money that will have to be dealt with when you pass away, possibly less complication. And in many states, the probate fees, as they are in Connecticut, are based on the size of the estate. So the larger the amount of assets that go through probate, that go through your estate, the larger the amount of fees you will pay. Now, you're able to gift up to $18,000 a year per person without worrying about going into your federal gift tax allowance. And the federal gift tax allowance is a little over $13 million. So it's almost laughable. But if you wanted to gift much more than $18,000 a year, it's not a problem for either you or the person you're gifting the money to. You really don't have to worry about any gifting tax because you'd have to gift over in your lifetime $13 million. You are supposed to fill out a gift tax return, but it is a pretty easy thing to do, but the actual taxes that are owed wouldn't come into play unless you're gifting over $13 million. Now, I've seen a lot of debate. It's interesting. I've seen a lot of debate on this recently on Twitter, and I followed some financial accounts, and some people are saying, it's much better to give to your children while they can really use the money. Many people can really use money in their late 20s or 30s when they're having a family, when they're possibly buying a home, when they're starting a business. And you can then see them enjoy this money and get the benefit from it, or you can wait until you pass away and they'll inherit the money. And the Twitter thread was arguing that receiving a lot of money later in your life can't make as much of an impact as it could if you receive that money when you're really building up your career, building up your net worth, and it could be much more impactful. So definitely something to consider. Tip number 2 is having real estate owned jointly. And this really makes the most sense for spouses. So when you buy your first home, maybe you bought it by yourself, maybe you bought it with your spouse, but if you pass away and your real estate is owned in a single name, that is usually an asset that has to go through probate. So one way to either not have this go through probate or really just simplify the settlement is to put a joint tenant on that asset. Now, I mentioned before, it's going to be the easiest if you're doing this with your spouse, if you're doing this with someone who's already living in the property with you, maybe a child, someone who you want to get this property, then that could really make a lot of sense to put your real estate in what's known as joint tenants with rights of survivorship. That's a joint owner that they have equal ownership of the property. Upon your passing, that property would go to them. Now, in order to do this, you would need to file an updated deed on your property, and that's something that can be done with the help of a lawyer. Sometimes just going to your local office at your town hall, you can do that. But the negative with doing this is that if you put a joint tenant on your property, say it's not your spouse, say it's your child, and you then want to sell the property down the road, they actually have to sign off on that. So if there was some disagreement about that, that could be a problem. But as far as settlement of the estate, it makes it a lot easier because you don't have to wait through this asset to go through probate to actually then go to the party that you want it to go to. Tip number 3 is joint ownership for other types of non-real estate property. So what other accounts can be held jointly? Well, bank accounts, investment accounts, stocks, other mutual funds, other investment accounts. As I said before, you could have those in single name, or you could add them someone on as a joint tenant. Now, like I said before, it's going to make the most sense with your spouse, especially if you want them to inherit this asset. Upon your passing, they would reach out to that financial institution, they'd fill out some paperwork, and then that asset would be moved over into their name. So that really makes the settlement of your estate a lot better. Because with probate, the process of settling probate is that everything upon your passing has to go into an estate account. So everything that's in single name or doesn't have beneficiaries, doesn't have a joint owner, would have to go into an estate account. So whoever is your executor first has to go gather up everything. And this is where the complication comes into play. They can't just go and gather the things up. They have to follow whatever procedures those investment companies require, those banks require to move those assets into the estate account. So it's usually a lot of paperwork, a lot of forms, and then gathering the money through checks, getting everything into the estate account, then going through whatever the probate process is in that state to then make sure they have then final approval to settle that estate, which means paying out the assets to whoever they go to. And then in the process, they have to also allow any creditors to come forward, anybody that you owed money to upon your passing or claims that you owed money to can make a claim against your estate. Those creditors would need to be settled, and then the estate can finally be paid out. And as I said before, for my grandfather who recently passed away, this took a year to go through this process, and his estate, as far as his will, was relatively straightforward. So because of this, by adding on a joint tenant, they don't have to go through the probate process to get these assets, and relatively easy. You fill out a form, supply a death certificate, and then the asset can be moved over into that other party's name. The negative, however, is that while you're alive, that other tenant has 100% right to those assets. So you want to be careful, because if you transfer these assets, let's say, into a child's name that maybe has a drug problem or an addiction problem, and they want to go and clear out this bank account without your permission, they can do that. So that leads me to then my fourth option or fourth tip as far as simplifying the settlement of your estate, avoiding probate, and that would be using what's known as a payable on death or transfer on death account. So with these types of accounts, when you add someone as a payable on death or transfer on death beneficiary, they don't actually have access to this account during your lifetime. They can't add money to the account and take money out. They have no access to the account. However, upon your death, they are a beneficiary on this account, and they would then go through the process that financial institution requires, usually providing a death certificate, filling out some paperwork, and then the asset could be moved over into their name. So this is a great alternative to using a joint tenant's account, a joint tenant with rights of survivorship, if you don't want whoever that tenant is to have access to those assets while you're alive, but you want them to get the assets shortly thereafter your passing. Consider setting up a transfer on death or payable on death account. And this can be done just like with joint ownership of non-real estate property. It could be done with investment accounts, bank accounts, stocks, bonds, many different types of accounts to make the settlement of your estate a lot easier. And I mentioned that before, a lot of my clients' money is held with Charles Schwab. I know that Charles Schwab offers this. I know that Fidelity has this. So this is an easy thing. And sometimes a lot of these financial institutions are actually now even allowing you to do this right online, where you can add a beneficiary rather than, sometimes there's paperwork, but it's an easy thing. Now, this can also be even a good thing for spouses, for couples. Maybe you and your spouse want to keep your finances separate. You have separate investment accounts, separate bank accounts, but you want to make it really easy on your spouse when you're gone. Then think about adding them as a transfer on death or payable on death beneficiary. Let's say you didn't do that. You have an account in your name, your spouse isn't on there. You pass away, guess what? That's going to have to go through probate. So this is a much better idea. If the joint tenant setup isn't right for you, think about payable on death. Tip number 5 is making sure that you have beneficiaries on retirement accounts and life insurance and annuities. So with some types of accounts, you can easily add a beneficiary, like a retirement account, annuity, life insurance. And you want to make sure you have these filled out. You'll be surprised how many people don't have a beneficiary on these types of accounts. This is something when I meet with my clients once or twice a year, we're showing them who their beneficiaries are on their accounts, just so they know, but also maybe they didn't actually put a contingent beneficiary. So I recommend that everyone not only put a primary beneficiary, but put a contingent. Now, if you're married in a relationship with someone, chances are your partner, your spouse, would be your primary beneficiary. But you should always think about putting a contingent. Maybe if you have children, that could be them. If you have grandchildren, if you have close family friends, other siblings, if your parents are still alive, maybe put them on as your contingent beneficiary. That way, if something happens to your primary beneficiary and you haven't updated your beneficiary designation, your assets then don't have to go through probate. So it's a great thing to do. It's very easy. And again, you probably should check your retirement accounts, your life insurance, and if you own any annuities, to make sure you not only have a primary, but a contingent beneficiary. Tip number 6 is considering using a beneficiary, setting up a transfer on death beneficiary for your vehicles, for motor vehicles. This is something that often gets overlooked when you pass away. If you own a car, if you own other types of vehicles, who is going to inherit those assets? Well, a lot of states will allow you to put on a transfer on death beneficiary. There's, I believe, 20 states. I did some quick research, 20 states, including Connecticut. So if your state offers that and you have this set up, it also makes the settlement of your estate a lot easier. It doesn't mean that this asset has to go through probate for it to move to whoever you want it to go to. So definitely investigate that and figure out if that's something you want to do. And tip number 7 is to think about creating a living trust, sometimes known as a revocable living trust. So this, in some states, can totally avoid the probate process. In other states, like Connecticut, it can simplify the probate process. What this is a trust that you're setting up where you're naming where your assets are going to go, how they're going to be received, meaning are the beneficiaries going to get all of the money at once? Can they only take a certain amount out each year? Are the beneficiaries going to be their own trustees upon your death? Or maybe if you have minor children, or you have children that you don't want to inherit a large amount of wealth, or you just feel that they're not ready to handle their own finances, you can name someone else as the trustee that would oversee these assets and then make sure they're distributed to your children or to the beneficiaries upon your wishes that you lay out in the trust. So this can be set up a number of different ways. You can do this online. There's a lot of companies now that will do this online. An example is a company like trustsandwills.com. For around $500 or $600, you can set up one of these trusts. Now, you're really not getting legal advice. So the next level above that would be to hire an attorney, someone who specializes in estate planning, to actually help you draft this. You're going to pay more, usually about like $2,500 to $5,000, depending on the complexity of your trust. So it's going to cost you more, but you're going to get a lot more advice. If you're someone who really knows what you want to do, if you feel comfortable doing it yourself, then maybe you want to go and do it online. If you feel like you want more expertise and you want some professional advice, then maybe you seek the advice of an attorney. And so that would be the first part, is actually drafting this trust. So once the trust is drafted, believe it or not, it's really not very useful, because then what you'd have to do is you have to go and put assets into the trust. Well, what does that mean? You have to retitle assets. So if you had bank accounts, you'd probably want to put them in the trust name. If you had non-retirement investment accounts, you'd want to put them in the trust name. If you owned real estate, you probably want to put that in the trust name. So you have to take these extra steps to actually put the assets into the trust for it to go through the trust. There are ways that your assets can go into trust through your will. That's a different setup. But this, if you create a revocable living trust, you want to make sure you follow the next step of actually putting the assets into the trust so that the trust is actually going to be used. So those are 7 tips on how you can really simplify the settlement of your estate and in some instances avoid probate. Now, I'm not an attorney, and I just want to preface that by saying that probate in many states is unavoidable, meaning upon your death, whoever is your executor is supposed to follow whatever the rules and regulations are for that state. In some states, you actually have to go through probate, even if you have done these things I've talked about, and your assets don't need probate to settle them. Meaning if you have beneficiaries, you have joint tenants, you have everything set up, technically you don't need to go through probate to settle the assets to get them into whoever they're going to, but according to the laws of certain states, you have to file probate, because probate still has to authorize the settlement of those assets. What if there were creditors that you didn't pay, or there are certain beneficiaries or certain people making claim to that estate? So you want to make sure that if you are thinking about this, you're thinking about doing this, you understand the rules in your state so that you're up to date. Some states, probate is avoidable. Other states, like my home state of Connecticut, it isn't. So you want to make sure you do that homework to know. But by following these tips, it's certainly going to make the settlement of your estate a lot easier. And it's also going to make the probate process easier if you have to go through it. So if you're new to the show or you're not signed up for my newsletter, head over to retirewithryan.com and sign up. And also, if you have a question that you'd like to have considered for a future podcast episode, you can also leave that question by going to retirewithryan.com and clicking on Ask a Question. Hope this was helpful. Have a great week, and I'll talk to you next Wednesday. Take care.